Welcome to the Employment Law and HR Podcast with your host, Alison Colley.
Hello and welcome to this episode 229 of the Employment Law and HR Podcast. I'm your host, Alison Colley. I'm an employment specialist solicitor and I run the firm Real Employment Law Advice, where together with my colleagues, we provide advice and assistance to both employers and employees on all aspects of employment law. We offer a range of services to both employers and employees, but our flagship service is our HR Harbour membership service, which is where we provide unlimited advice and assistance to employers for a monthly fee, as well as having unlimited access to a solicitor or specialist in employment law. You will also have access to a range of resources, including our monthly webinars. So if you are looking for further support or if you're looking to change your provider for external HR and employment law advice, then why not get in touch for a no obligation quote? I'd love to have a chat with you about your business and what your needs are. So please don't hesitate to get in touch. My email is alison@realemploymentlawadvice.co.uk. Without further ado, I'm going to get into this week's featured content. In today's episode, what I'm going to be covering is an overview of the rights of directors as employees. Now, over the years, I've dealt with a number of employment matters which have stemmed from a dispute with directors or shareholders within a business. So typically what happens is a couple of people, maybe one or two, maybe more, get together and start a business, and they are all shareholders of the business and they all become executive directors. So that is to say they are directors who are members of the board of the company, but they are also employees of the company. And so together they work and they are working towards the benefit of the company. And over time, those relationships can sometimes fall apart, disputes can arise and various things can happen. And typically what I've seen is that one or more of the directors and shareholders get together and then tend to oust another person. I say typically, there are a range of ways in which companies are made up and various setups, but typically in the disputes I've seen, there have been 2 to 4 shareholder directors and something's happened, there's been a fallout or whatever, and then one of the employee directors ends up being dismissed or having to leave because of the situation at work. Now, in those situations, there are 2 things that tend to happen. The first is there is normally a dispute around their employment rights, because as a director, they are also an employee, but then also in relation to their rights as a shareholder of the business. Now, my remit doesn't cover company law, and in these scenarios, I always recommend speaking to a specialist in company law and can often refer you on if you do find yourself in that situation. But there is one thing you can do in relation to protecting your rights as a shareholder of a business, and that is to ensure that you have a good shareholders agreement in place. I understand that there's all the excitement of setting up a business. You might not be thinking about getting legal advice at that time, or you might not have the funds even to get legal advice on a shareholders agreement. But I would just reiterate that it's so important to protect everybody's rights and to get the relationship off to the right footing by having a shareholders agreement in place. That's relevant to the business and contains the terms and protections that you want. So I would urge you to seek advice in relation to that and get a shareholders agreement in place. If you are a shareholder of a business and you don't have one, even if you're not in dispute, it's a really good time to get it done now. So setting aside the company issues, so the shareholder rights and the company requirements, as an employee of the business, you also have rights under employment law in exactly the same way as other employees would. And sometimes this can be overlooked by directors in a business. They often forget that actually their fellow directors are also employees and have those rights. And this is where often people end up coming to me because they have been unfairly dismissed or they have been treated to their detriment. And so therefore, their resignation then prompts a claim under constructive unfair dismissal. So just by way of a reminder, employee directors also have the benefit of various employment protections. So they should also be provided with a contract of employment. Now, if you are a director of a company, then you are equally responsible for getting together with your colleagues and preparing your employment contracts. If your fellow directors are not really interested in putting together employment contracts, then take it upon yourself to set that up. You need to have in place clear terms of your employment contract, setting out what your rights are. And I'll come back to that in a moment. The second thing is, the second right obviously is to have a minimum period of notice. So whether you're a director or not, the legal minimum notice period continues to apply if you're an employee. So that is to say, if you don't have anything in writing, the minimum is 1 week for each year of continuous employment. There is also the right to be paid at least the national minimum wage. Now again, this is a common issue that I see in relation to directors of businesses who are also shareholders. Sometimes they will forego their salary or have a reduced salary at times in which their cash flow for the business is needed. So, it's an investment into the business, as a shareholder and director, you would do that. But it's really important to check to make sure that all of your fellow directors are being paid the national minimum wage as well. Because there is a right to be paid the national minimum wage, and this is based on monthly records. So if you are paid a reduced salary for a month, you work out what that is based on the hours worked in that month to ensure that it covers the national minimum wage. It doesn't matter if the next month then you're paid double, because if you were audited by HMRC, they would look at the pay period as the reference period for calculating national minimum wage, and if that's monthly, it will be the month in which it's paid. So it's really important not to forget that you are entitled, and your fellow directors are entitled to the national minimum wage. There is, of course, the limit on the number of hours that can be worked under the working time regulations, as well as holiday. But as you may know already, you can opt out of the 48-hour work week, which often directors and shareholders will do because they work more hours especially at the beginning of the business, to build it up. So ensure you have that opt out for the maximum number of hours worked. And of course, remember that your fellow directors are entitled to paid holiday as well. And I would say, if you are in business with other people and you are all directors and shareholders, then you should be looking after each other and making sure everybody takes their holiday and it's covered. Again, when you're really excited about a business, you're working hard in it, you can often forgo your holiday. But I would say it's important that everybody has a rest, so look after your fellow directors. There is also the right, of course, to be paid statutory sick pay in periods of illness or incapacity in much the same way as any other employee. And if there is a redundancy situation, then there is a right to a redundancy payment. Again, that doesn't come up as often in relation to reasons for termination of directors' employment, because often the directors are the ones that go last if there is a need to reduce the number of employees. But it's important to note that employee directors are also entitled to redundancy pay. And directors are also entitled to things like maternity leave, maternity pay, shared parental leave, paternity leave, adoption leave, time off for dependents. All of those parental or family rights that a normal employee would have also apply to directors. And then finally, of course, just noting that the rules around discrimination under the Equality Act also apply. So what am I saying in summary is that it's really important to note that yourself as a director employee and your fellow director employees all have employment rights in the same way as other employees. Now, one of the questions I've been asked recently by somebody who was in dispute with their fellow directors is, what can I do to help to preserve my rights in the event of a dispute with my colleagues? Well, there are a couple of things that you can do if you are a director Whether you're in dispute or not, actually it's better to do it before you get into any kind of argument with your fellow directors, is put in place clear contract terms. So set out what will happen in the event that there is an issue with performance or conduct of a director. How will that be dealt with? And who makes the decisions there? Again, quite often disputes arise because one director takes it upon themselves to discipline another or to question performance, and they have nothing in writing. No ground rules are set about this, no targets are set. So in much the same way as you would for any other employee, it's important that you set out what is required of that person in their employment role and also what the measures are for success. This will really help in terms of resolving disputes, both for you as the individual, but also for the company. So make sure you have that in writing. Again, also deciding who is going to make the decision and who has authority to dismiss a fellow director. Now, what you don't want to do is to make it so onerous that you end up in a situation where the relationships are toxic and there is no way out of it to the detriment of the business. But equally, you need to ensure, if you are trying to preserve your own rights, that you have those processes in place. So, for example, you could say as a minimum, a decision about dismissal of a director must be taken by 2 directors, or you could say in the event of a dispute or question over the performance or conduct of a director, then you all agree to appoint an external, independent person to investigate and deal with that issue. Now, in my view, that's one of the best ways of dealing with director misconduct or capability issues or issues around performance, is to appoint someone external like ourselves who would come in and investigate and look at that independently. That way it takes away those personality issues or any potential argument that there's been some kind of collaboration between directors or there is some other agenda involved. Now, aside from having in place clear paperwork, employment contracts, processes, job descriptions, measures for performance, the key thing in relation to relationships between directors and preventing these things from arising is communication. Quite often, it can be stressful running a business. You're under pressure to bring in the money, to pay the bills, to pay the wages, and you can become frustrated with your fellow directors, particularly if you feel that they're not necessarily pulling their weight. And so I would say having clear lines of communication, having an open and honest and upfront relationship, and maybe even setting out those boundaries of that communication and how you will deal with things at the outset. It was really important to make sure that not only do you prevent problems from arising, that it makes it much easier to deal with those problems when they do arise. One of the things that you could say, again, is that if there is an issue in relation to communication or misunderstanding or any kind of dispute, that you will, as a default, start with mediation to try to resolve that. So that any director can say, look, I think we need to obtain a third-party mediator to enable us to communicate around this issue. Really, when you are starting a business or you're investing in a business and working in that business, what you want is for it to succeed. And as soon as those disputes start to happen amongst directors, there is inevitably a dip in performance of the business. And quite often, in my experience, where that happens, it can end up being sometimes fatal for the business. There can be no coming back from that. So the more ways in which you can prevent those disputes from happening, the better. Another question that often comes up in relation to director employees is whether you can terminate the employment of a director employee who is no longer a director of the business. So I've talked about the fact that quite often what happens is, especially in small businesses, you have shareholders who invest in the business, but they also work in the business, are directors, so are on the board and hold positions in relation to company law. And they are also employees of the business, so they have a job role in the day-to-day running of the business. Now, what can happen is something may trigger the dismissal of that director from the board. So sometimes, if there are, bankruptcies or credit arrangements or criminal conduct, various things, or, breach of the company's rules, the employee director may be removed as a director from the board. So they no longer hold that position. And sometimes the employment contract can then state, for example, once you are no longer a member of the board, if you're dismissed as a director, then your employment will automatically come to an end. Now, again, this is one way that has been used in the past by directors in disputes to remove somebody from the business. So they remove them from the board for what is a legitimate reason, either set out in the Articles of Association or by company law, and then they then utilise the fact that they're no longer as a director to then remove them as an employee. Now, it's important to note that if the director employee has been employed for more than 2 years, then their rights in relation to unfair dismissal continue to apply. So you need to have a fair or potentially fair reason for dismissal, and in many cases follow a process before terminating their employment. And it can be difficult to justify the dismissal of an employee merely because they are no longer a director, particularly if they fulfilled a fundamental role in the business or a role in the business that can continue even though they're no longer a director. Now, of course, if their role is intrinsically tied to being a director and therefore they can't fulfill their employee role because they're no longer a director, and that's, legitimate and true and can be shown, then that would be a potentially fair reason for dismissal. It would be for some other substantial reason. But otherwise, it's important that you seek advice before you terminate the employment of somebody who was a director whose directorship has also been terminated, because you can't necessarily just rely on the clause in the contract that says that you can do this. Now, finally, if you are dismissed from your role as an employee and you were a director and you're a shareholder of the business, then of course you can pursue a claim in the employment tribunal if you feel that your dismissal is unfair, or if you've been forced out by your fellow directors and you've had no choice but to resign, you can of course claim constructive unfair dismissal. And what happens normally is your employment tribunal claim runs alongside the resolution in relation to your shareholding of the business. So quite often, as I've said earlier, you would have two sort of sets of advice from two different specialists, one from in relation to your rights as a shareholder under company law and the other and your rights under employment law. And quite often, not always, but quite often, the value of the shares and the shareholding is higher than the employment claims, because typically directors are normally paid just the minimum wage because the rest of their pay is normally taken in dividends, so they get a low salary. And when you're talking about an unfair dismissal claim, your claim for compensation is for loss of earnings, and which therefore would be limited if you had a lower salary. If you're claiming discrimination, of course, then there is an injury to feelings award and there is no cap on the amount of compensation that you could obtain. But typically, we're talking about unfair dismissal claims, the shareholding is worth much more than the employment claim. But it should still be considered and potentially pursued. And also, in terms of trying to negotiate in relation to your shareholding, sometimes it can be helpful to have that employment tribunal claim going on, because you can then sometimes wrap that into any settlement in relation to the shareholding. So in essence, you can kind of wrap together the two things, namely you can resolve your shareholding issue, potentially get paid for those shares or the value of those shares in return for agreeing not to pursue your employment rights further. But again, if you're in this situation, I would strongly recommend that you get advice either way, because what you don't want to do is inadvertently waive your rights when you can have a very good and maybe lucrative claim against that employer. And then the final thing I want to mention is in relation to the balance here. And often I talk to employees who have been dismissed, who are also shareholders of the business, about the fact that Of course, any money that is used to pay the legal costs of defending an employment tribunal claim and any compensation that's paid by the company for your claim for unfair dismissal also then can bring cash out of the business and therefore potentially have an impact on the value of your shares. Again, you need to be taking these kind of things into consideration, thinking them through. It does very much depend on both the value of your employment claim and the value of your shares, how well the business is doing, what the finances of the business are like, as to whether that's an issue for you. But sometimes, we've had a conversation with a director employee where the business is really on the edge of falling down. They've got no cash. They've actually got very little value in the business altogether. And sometimes that employment tribunal claim can tip it over the edge. So it's really important to keep these things into consideration in relation to your rights. Importantly, you have to remember that you only have 3 months less 1 day to pursue your claim in the employment tribunal. That is to say, you have to start the ACAS early conciliation process. And if that's not successful, then your time limit is extended slightly in relation to that. So you don't have a lot of time in relation to making those decisions. So sometimes it may be that you put in your claim or you start the claim process to preserve your employment rights whilst the shareholding issues are ongoing. So to summarise, in relation to the rights of director employees, if you are an employee of the company as well as being a director, you do have employment rights. You have the right not to be unfairly dismissed after you've been employed for more than 2 years. You also have the right not to be treated to your detriment because of a protected characteristic. The ways in which you can protect and preserve your rights as an employee director is to ensure that you have a contract of employment in place, clear job description, and measures or targets in place that can measure performance in your role. I would also strongly recommend that you have good lines of communication and clear means of resolving disputes set out at the outset, utilising mediation where possible to head off issues before they really become big issues. And of course, if you find yourself in a difficulty, either before dismissal or after dismissal, it's really important to get some advice and we'd be happy to have a chat with you about it. You can contact me by email. It's alison@realemploymentlawadvice.co.uk, or you can contact our office on 01983 897 003, where we'd be happy to arrange a no obligation conversation with you, either about how to protect your rights, get the employment contracts and paperwork set up, or to deal with a dispute should it arise. Thank you so much for listening to this week's episode of the podcast. I'll be back with you in 2 weeks' time. If you have any suggestions for any content or anything you would like covered in a future episode, please don't hesitate to contact me. This episode came out of the fact of somebody asking for this content, and I'm really pleased because it means that it's very easy for me to put together the episode. So please let me know if you have any ideas for content or anything you'd like covered in future. I hope you have a fantastic week ahead and look forward to bringing the podcast to you again in 2 weeks' time. Thanks again for listening. Just want to finalise by saying I wouldn't be a lawyer unless I had a legal disclaimer. So I must just say to you that the information in this podcast is for information only. It's general review and a general update. It's always necessary to get specific legal advice about your circumstances. So please don't rely on anything that you've heard in this podcast. But please do feel free to contact me if you'd like further information or specific advice.